Tuesday, we bring in immigration updates from Houston, Texas, from 5 p.m. to 6 p.m. We take live questions. So if you have any questions, please post those questions. We'll try to answer it. Emily, what do we have today to discuss?
Today we have Senate Bill 3291, otherwise known as the EAGLE Act or the Fairness for High-Skilled Workers Act that we've been trying to get passed for a decade now, that would eliminate the per country cap that's creating this backlog for India and China. So we have a senator that introduced it. We don't have the text of the bill yet, but we do expect it to be similar to last year's bill. So we'll talk about who is introducing that, what exactly it means that it's in the Senate versus the House, what's the timeline, what actions do people need to take going forward. And then a common question that we get is about people entering on advanced parole. So nowadays everyone gets a 5-year advanced parole with their EAD renewal, but when they come back into the country and they get their I-94, they print it out from the CBP website, it only gives them a 1-year admission. Do they have to worry about that? What exactly does that mean? Is there any action that they need to take? And then a common issue that we're seeing right now for kids of legal immigrants, the legal dreamers that are at risk of aging out, they're at the age now where they're applying to colleges, and colleges are asking as part of the application process about your immigration status. Can you use your AOS or your EAD as your immigration status? What if the college application doesn't have that option? Can you still even apply? So what do we do in that situation? So getting back to the Senate Bill 3291. So this was proposed by Senator Kevin Cramer, who's actually a Republican out of North Dakota, and it has 2 co-sponsors. One is John Hickenlooper, who is a Democrat out of Colorado, and then Susan Collins, who's a Republican out of Maine. Now, of course, it's just introduced. We don't have the text yet, but it's got a long way to go. The first question is, does this particular bill have to be passed by the end of this year, or do we have until the end of next year to get this passed?
The good part is, Emily, that we have until the end of next year to get this bill passed. Nothing, because this Congress is going to be there until the end of next year. So we have good time to pass this bill. It's been introduced at the right time. I know there are a lot of voices that will say, they're going to keep crying now. Why do we have to do it? Well, if you compare this one to Emily with regards to some of the things what go on in the Congress and sometimes the administration, if you recall, the DACA people, though, they tried so many times getting this kind of bills passed, though. They couldn't pass the bill. Of course, eventually, I have seen senators crying on the floor to pass this bill. It was Senator Reid from Nevada who cried on the floor to pass this bill, couldn't pass it, though. Yet, it came in an executive order at the time of Obama, though. Now, of course, I urge all the people to urge the congressmen and senators to pass this bill. I know that previously we have failed a couple of times, but Emily is going to give you more details of how we failed, how we improved on those things, what are the probabilities. We're going to give a draft of this one probably next week for you guys. Once we see the content of the bill, we're going to draft a letter and give it to you. Emily, why should people write letters? You said from past 11 years. I would say it's been past many years that we're trying to get this bill passed in the Congress. We failed many times.
Yeah, but those past failures can set the stage for a future success. So you have to be persistent. You have to be resilient. You can't just give up when you're at the very end. Because if you give up now, you're doing nothing for your family, your future, or anything. There's got to be, there's always going to be a struggle with any kind of progress. And also just be aware of the progress that has been made on this bill over the years. So I looked back at all the different times it had been introduced. The first time that it was introduced in the House, or one of the very early times, there were 11 co-sponsors of this bill. This is in 2011. And actually that year it did pass the House back in 2011. But then 2 years later, there were 14 co-sponsors. 2 years after that, 2015, 147 co-sponsors. 2 years after that, 2017, over 300 co-sponsors, and again, over 300 co-sponsors in 2020. And that's progress. I know it doesn't result in what we're wanting, the final result, but that's definitely progress, and we can build on that. And there's other things that have happened. You know, originally it was the Fairness for High-Skilled Immigrants Act, and then it became the EAGLE Act. There's been changes made to it over the years based on some of the opposition that have come up. And some of the more recent opposition tends to come from the healthcare workers, where they use, you know, the Schedule A green cards. They typically are able to actually sponsor people without a very long wait if they're not from India or China, and they skip the labor certification. So obviously we have a healthcare worker shortage, particularly for nurses. And so some organizations were coming out saying, hey, if we pass this, I'm not going to be able to get nurses to staff my hospital like I have been, because our wait is going to increase. Rest of world, other countries are going to increase. So to combat that, at the same time that this bill has been introduced, there's a healthcare worker bill that's also introduced that sets aside 40,000 green cards for nurses and doctors in certain circumstances. So I feel like they combined, the bills are not combined themselves, but the timing of the bills is to move them through together so that we can at least overcome that most recent objection to this bill. And it's just really important to remind people that we're, you know, not trying to get any special treatment here. We're just trying to eliminate the discrimination, put everybody on an even playing field. Employers should not have to take country of birth into consideration when they're deciding whether to sponsor someone or whether to hire someone or not. They should be able to hire whatever talent they think they need and not have to think about what country they're from. And so I think those are some of the ways that we need to frame this, show people that there's been progress, that there's hope for future progress and moving forward. And it all comes down to that advocacy, which is not just retweeting things on Twitter or commenting to the president on Twitter or even commenting to your congressman or senator on Twitter or Facebook. It's sending letters, it's writing emails, it's meeting your senator, meeting your congressman's office, and sharing your story. Tell them how you've contributed to this country, what the future holds for you, what it holds for your kids if they age out. There's a lot of support for age out kids and trying to remedy that situation. So to show how this bill would remedy that, I think is important to bring forth. So as Raul said, once we have the text of the bill, we will be putting out sample letters as well as instructions for how you can send that to your particular senator or congressman. We ask you all to do that so that we can keep this moving forward.
Anyway, you guys are coming to our show from past couple of years, and you will be coming to our show in the next couple of years too. All we're requesting is to spend about 15 to 20 minutes extra to write the letters. Please write the letters to the congressmen and senators to get this one passed. As Emily has pointed out, that every time this bill has hit the Congress, there has been a progress. Now, of course, we didn't win it, but we did perform very good every time. From 2011 onwards, all the way to 2020. We missed in 2020 just by a little bit, okay? Now, we don't need to win every time, guys. We only need to win once. That's all we need to win. Every time we lose, we get another chance. But we win once, that's it, we're off. You won't be our clients. You don't need to come to this YouTube channel, which is very good. I want you to enjoy with your family and all those things. You don't have to be, every time you go to stamping, you don't have to go spend time for getting the stamping to see if you're going to get the stamping or not. And the dates don't move at all. If this bill passes through, though, we have to see the content of it. Definitely, I will tell you that the priority date will move very fast. No matter what format they're going to put this bill in, the priority date will move very fast for those country people who have been discriminated historically in the employment based. It will move much faster. So I urge people to contact the congressmen and senators, as Emily pointed out, go meet those people, write a clear description. We're going to give a rough draft to you. We're going to give you some blanks. You need to give some personal information to them. Where do you live? What you work as? Do you have a family? Do you have a house? And what is that you do in the profession? Please spend a little bit time to write. And what other options that you have? People will say that, Rahul, why are you keep on having them writing letters to those people and we're not getting any result? Yeah, I mean, what other options we have? We don't have much options. This is the only option. This is a democratic country. We need to win. We need to voice. Look at how the people who don't have documentation, they voice a lot. They get a lot. For asylum, they get out. For DACA people, for those people, 1 million kids who came not legally staying in United States, they got the work permit. But we didn't because we don't voice. So definitely this is a choice in 2011 to 2020, as Emily has pointed out, the progression that happened. We have so many supporters in the House. We have so many supporters in the Senate. We narrowly had some technical difficulties, and because of the election at that point of time, and there was a lot of problems going on at the election result, we couldn't get this one out in the right time. It missed by a day, I would say. Had it been passed a day before or 2 days before, it would have had a time to have both House and Senate combined together and have this bill passed. So hopefully, this time, you are going to contribute by writing the letters to the congressman, writing the letters to the senator to pass it. Hopefully, it will be passed, and then the priority date is going to move. Anything else, Emily, before we go to the next topic?
Nope, I think we can move on to this advanced parole. So I just renewed my advanced parole. I got it for 5 years. It's good till 2028. And I traveled, used my advanced parole to come back in, and I go online to the cbp.gov website, enter my passport information, and it says you are entered in DA, whatever category that is, and your end date is 1 year from now. What exactly does that mean? Is there anything that people need to do?
No, they don't need. Only this time, Emily, only this time. They don't need to worry about the expiration date of the I-94. Only this time. Please don't use this for any other purposes, though. If you are coming in advance parole, if your advance parole is valid for 5 years, they do not give the validity for 5 years. They only give validity for 1 year online, but you can ignore that.
Uh-oh, I think we may have lost Raul there, but what he was saying is this is the one time it's okay to ignore what that I-94 end date says online. It is your pending 485 that keeps you in lawful stay in the United States. So as long as your 485 is pending, even after that 1 year date expires on your I-94, you can continue to remain in the US and continue to work using your EAD. If you have your underlying non-immigrant status valid still with a valid I-94, you can use that status as well. So even though you're entering on the advanced parole, you can still continue in your H-1B status, your H-4 status, your L-1 status, your L-2 status, even though you've entered on the advanced parole. So you don't have to worry about that. And we are seeing improvement in the processing times of these renewals. There's the people that have filed later are getting approved earlier. You know, we see time and time again, USCIS doesn't seem to follow a first in, first out process with a lot of their cases, especially when the processing time increases and people start to complain. They finally start speeding things up, but only for the people that most recently filed, and the people that filed earlier have to wait longer, which is not exactly fair. But there are things that we can do. So if you're stuck with a long pending advanced parole or EAD, we can use litigation as a way to move that case forward, even though it might still be considered to be within normal processing times, because their normal processing times are quite ridiculous still. So that's it on advanced parole, the 5-year validity, even though you're only getting a 1 year I-94. The last topic is particularly for people who have college age kids in the US. The kids maybe are on H4 or they're aging out and switch to F1, or maybe they have a pending 485 and have the EAD based on that 485. But the 485 is still pending. And so now they're applying to college And we're facing some hurdles in just the application process because all of this is online now, and each school has a different way to apply unless they have kind of a common app that different states have, like Texas has a common app. But the problem is for some schools or some applications, when it asks for immigration status, it gives an option for non-immigrant, like H4 or F1. It gives an option for permanent resident, for U.S. citizen, for asylee, for refugee, for TPS, for DACA, all these different options, but there's no option listed for someone who has a 485 pending or an EAD based on a 485 pending. The 485 pending is a lawful status, and you are eligible to study while you are waiting for your 485. So it may be necessary for you to reach out to the school's admission office to get more guidance on how exactly to get past that section if you have just the pending 485 and no longer have that underlying non-immigrant status. Otherwise, if you do have the non-immigrant status underlying and it has not expired yet, you could list that as your current status, even if you also have a 485 and an EAD. So I would definitely suggest reaching out to the admissions office if you're facing that issue. Sometimes schools have those questions on there so that they can kind of keep the F1 international student population separate from the rest of their student body, just for their own compliance purposes, because students that are on F1 have a lot more compliance issues that they need to worry about from the school's standpoint compared to people that have other immigration statuses. But sometimes it's just a lack of knowledge of, what is this AOS EAD? We even have a situation with people who are applying for a TWIC card to be able to do some highly sensitive work that they were completely authorized to do while they were on H1 or H4 EAD or whatever it is, and they can do if they're a green card holder or a citizen, but there's no option for AOS EAD in order to apply for this. So it's just a silly oversight, I think, a lot of times with different government agencies. We even see it in driver's license renewals and that sort of thing. All right, so while hopefully Raul will join us soon, we will move on to some questions here. All right, so first question from Vivek. I have the EB1C. I've been waiting for the 485 approval. The I-140 has been approved for a year now, and the EAD AP is all approved. And he wants to know, can I switch the job without impacting this EB1C applications, and what are the steps? So even though you're in the EB1C category, which required that qualifying relationship with your company abroad, you do still qualify for AC-21 job portability. That means that if your I-140 is approved and your 485 has been pending for at least 180 days, you're eligible to change employers to any other employer as long as the job that you're being offered with that new employer is similar to the job that you were originally sponsored for. So yes, you can change jobs at this point. You need to make sure that the new job is similar to the job that you were sponsored for, meaning it should probably be at the similar managerial or executive level of position. It doesn't necessarily have to be in the same industry or anything like that. And you don't have to have any kind of qualifying relationship between the company that you worked for abroad and the company that you're moving to in the US. How does the new company proceed with that situation? They will at some point need to submit an I-485 Supplement J form. That's the form that is used to show that there's a bona fide job offer and that you're using that portability. It's not necessarily mandatory that you file that right away or when you first join the company. These days, we're not really seeing any adjudication of the 485J supplement, so we typically are recommending don't submit it until you either get a request for evidence asking for it or you get called in for an interview and you need to bring it to the interview. It's up to you or in your company if they want to proactively submit it when you join. And that form is fairly simple. It just asks for the company name, tax ID number, their location, the job title of the position that they're offering to you, the job duties and the salary, and then they sign that to confirm that they are offering you that job.
Ajay Sundaration has this question. If he has an advance parole for 5 years, can he leave the country for a period and wait until, let's say, 2-3 years and come back? And when the priority date is current, can he get the green card at that point of time? No, that's not a good option at all. The reason is that you told USCIS that you want to stay in the country and you want to get the green card in the country. And if you leave the country and you go outside the country, technically speaking about, you have abandoned the 485 application. Even though they have given an advance parole, it's only valid for temporary travel outside the country, not for you to stay for a couple of years outside the country. Sorry, guys, I had some technical issues. I had to log off to come back.
Clevy says, is an H-1B transfer needed to change to employer B after employer A has filed the I-485 and it's been pending for 6 months and the EAD has been received? It is your choice and the new employer's choice. Since you have that EAD now, you could choose to use the EAD to join the new employer, or you can choose, if you're still maintaining your H-1B status, to transfer and file a change of employer for your H-1B so that you can continue your non-immigrant status. There are pros and cons to both. Most of the pros are with moving forward with just the EAD and getting the AP, since those are being issued for 5 years now. That way you don't have to worry about maintaining your H-1B status. Is the employer paying you properly? If you're working in third-party placement, can I get an end client letter? Do I need to go for stamping? All those things go away if you're using the EAD. There are some cases where it might make sense to keep the H-1B status, such as if you have a spouse who's on H-4, and maybe outside the country, needs to be able to get back into the U.S., or maybe you have a child that might age out and they haven't transferred to F1 yet, things like that. But for the most part, a lot of people are able to use the EAD instead.
Kelby26 has this question. For the first time people are applying for advance parole, are they getting advance parole for 5 years? The answer is yes. We are noticing that all the advance parole approvals that are coming recently are coming for 5 years at this point of time. So it's a good news for a lot of people that it is coming for 5 years. Sarvanan has this question. He has been in this country for 10 years plus. He has children. He has been paying high taxes. He has written 4 letters to the congressman. Didn't happen. Is this going to happen this time? What is the progress of this one? This is a democratic system, though. There is a way to voice. There is a way to get the attention of the congressman. And maybe 4 letters are not enough, and then we have to keep writing, because now those 4 letters are gone. Now we have a new legislation that come in. We probably want you to write the letters again for this particular bill, which is Senate 3291 bill. We want you to write it again. Question from Ashish has this question that why can't we protest in Washington, D.C.? Yeah, that can be done too. Nothing wrong with it. You can protest it too. But not many people from California, from Florida, they may not be able to travel at one particular given day where you are going to organize and get the permission. But yeah, if you want to do the effort to have a protest done in Washington, D.C., why not? Do it. It's going to help definitely. It's going to help definitely. But make sure that when we try to get the attention of the media, though, don't try to get the attention of the Indian media, though. Try to get the attention of the US media. That's the best source, because the senators, the people who work in Senate office or Congress office, they don't watch the Indian media. They do watch the local US media.
Joe says, I have a 2018 priority date for EB to India, and his brother just became a U.S. citizen and wants to know if it's a good idea to proceed with the green card process through family sponsorship since he's already in the U.S., and what are the benefits. So you certainly can have your brother petition for you under the family-based category. However, on the family-based side, the F4 category is for brothers and sisters of U.S. citizens. It's even further backlogged than your EB2. So that's a 2005 cutoff date, which is quite a bit worse than EB2. So you don't get to keep your 2018 priority date on the family-based side. They don't switch that way. So you're going to have a 2018 EB2 I-140 approval, and you might have a 2024 F4 I-130 approval. Whichever of those happens to become current first, you can certainly proceed with that process. I don't know which one at this stage is going to become current first, so it doesn't hurt to go ahead and do both. But just the filing of the I-130 petition by your U.S. citizen brother alone does not provide you with any immigration status, just like an I-140 doesn't give you any status. You can't keep extending your H-1B based on an approved I-130 like you can for an I-140. So you're just going to have that on the side in the back burner, but it doesn't give you any benefits like an I-140 does.
Asim has this question. Can a person who's an H-1B form an LLC and rent a car on Turo? The answer is no, because that will be considered to be working, though. If you are on H-4 EAD, definitely yes. If you're on 485 EAD, yes. But if you're on H-1B, no, that's not allowed.
Vinod says, can H-4 dependent children work while they are in college? Are they eligible to get an EAD? No, they cannot. If they're on H-4, the H-4 EAD is only available for spouses, not children. So if you want your kids to be able to work while they're in college, they need to change status to F1. And then during the summers, for example, they can get CPT to do a summer internship or something like that.
Can I have multiple employers file I-140 on my behalf simultaneously? Perfectly fine. You can. If you have people who are willing to file, whether it's a EB1 or it's a EB2 or EB3, if they're filing multiple, companies are filing a labor certification and want to file an I-140, absolutely fine. No problem with it. Arun Rao has this question. My initial advance parole, it's been pending for more than 18 months. I could not create a service request. What should I do? The best option for you right now, if you want to get this thing done, is probably go to court, though. If you want, you can contact Stephen Brown from our office. He keeps filing these cases in the federal court. That's a better option to get those things adjudicated. Otherwise, they're taking a long time to get these things approved.
The optimistic investor says my AP will expire in January 2024, currently on H-1B, planning to go to India in December. Does it make sense to wait until I come back to apply for the AP renewal? Does it expire if I travel? So if your current AP were valid longer and you were going to go and come back before your current AP expires, then it's fine to file the AP renewal and it will not be abandoned by you traveling. But if you're not coming back until after January 2024, after your current AP expires, then you might be in a situation where it makes more sense to wait until you get back to file that renewal.
Sorry.
Botic says, can we choose the field office for filing the I-140 for EB2? Texas is backed up two times more than the Nebraska Service Center. Unfortunately, no. You cannot choose the field office or the service center for anything that we file. It's either based on where your company is headquartered, where the job is located, or just sometimes they have just one address for all case types. They have been moving I-140s around recently. You would think Texas would get better since they moved all the 485s away from Texas, but the backlogs continue there.
Arpita has this question. Can a H-1B dependent who's an H-4 EAD buy a convenience store on their name? Absolutely, you can. H-4 EAD can do anything they want to. There's no restriction, none whatsoever at all. So yeah, you can buy a convenience store on your name and you can be the manager, run the convenience store. Mandar Joshi has this question. Can a person rent the second home on H-1B? The answer here is yes, though. No, I said no to the two-row, but I said yes to the home. Because home renting, you don't have much activity to do. You just rent out, and then it keeps going on for a year or so. But when it comes to the two-row renting, though, it's every day you have to rent it out. You have to speak with those people. You need to do a lot of work. That will be considered as working. But renting a home, second home, definitely will not be considered as working. You can definitely rent out, not a problem, on H-1B.
Sanyas Naidu says the H-1 extension was applied last June, and an EB-1A I-140 premium processing was applied in November. Both applications are at the Nebraska Service Center, and both got an RFE on the same day. Is there any relation between these applications? Generally, no. I think that's probably just a coincidence. Usually the H-1B and the I-140 are processed by completely different departments within USCIS. So it's very likely that there's no relation at all, even though they happen to be at the same service center.
Question from Nature Lover. Can a H4 person stay without work permit? That means that they're H4, no EAD. Can they work for a remote job of Canadian job and they have a Canadian work permit? The answer is no. Since you are staying in United States, you come under the jurisdiction of United States. Since you don't have a work permit here, you cannot remotely work. At this point of time, neither the Canadian government, nor the US government, or the Indian government, none of those governments accept cyberspace as a space. We only consider where you are physically sitting in United States. You must have a work permit to work in United States.
Gayatri says, my husband currently has an L1 RFE. We are yet to receive the response. If we apply for the I-140 and premium now, will it lead to any issues? I think it depends. If we're talking, if this is an L1A RFE questioning whether the position qualifies as manager or executive, and you're getting ready to file an EB1C I-140, where you have to prove that the position is manager or executive, it may make sense to wait until you know the L1 has been successful before you file the I-140, because the documents and the qualifications are very similar, if not exactly the same. But if the I-140 is in EB2 or EB3 and has nothing to do with the issues that are brought up in the L1 RFE, then yeah, it's not going to be any issue to apply for that. When you file an I-140, there's no question about your status involved. So we don't even submit any of your visa status or proof that you're maintaining status, because it's not part of the I-140 petition. The I-140 is just to prove that the company has offered you a permanent position. They have a labor certification approved if it's EB2 or EB3, and they have the ability to pay the salary offered. None of those bring your status into question.
Mohammed Sohail asked this question. His entire family got an advance parole, but he, the main applicant, did not get an advance parole. Is this normal? We see that very often. It's nothing odd about it that the entire family got it and you did not get it. We see that very often right now. Executable has this question from YouTube. What are the repercussions of working outside H-1B MSA long term? Can one apply amendment at a later date? The answer is no. You have to apply the amendment before you move into the job. I want you to immediately contact an immigration lawyer, especially your company lawyer, so that you can resolve this issue rather than prolonging this issue.
And Neil says, my EB3 priority date is August 2014, and my son is 17 years old applying for college. Does he need to switch to F1 when he turns 20? And what happens to him when he turns 21 if the priority date is not current? So I'm assuming you're on H1B, so your son is on H4. He is eligible to remain on H4 until he actually turns 21. Back a few years ago, the processing time of getting that change of status from H4 to F1 was over a year. So we were routinely telling people, file for it by your 20th birthday to make sure that you get it approved in time, because we were also having to file these crazy B2 bridge applications. That's all cleared up now because we have premium processing for changing status from H4 to F1. So you could wait a little bit longer into, you know, at 20 years and 6 months if you wanted to. But if you're doing that, then he won't have a way to do internships or take a summer job or anything like that. And then what happens when he turns 21 if your priority date is not current? You know, he may face aging out of your green card, and then he's going to be on his own going forward and responsible for his own immigration. So from F1, he gets the OPT, then he gets an H1B or an O1, and then goes through the green card process on his own, unless he qualifies for, you know, one of the family-based categories after you receive your green card.
Vagabond Bong Desi from YouTube. He has this interesting question, and this is a very common question. We get it though. He's on the 60-day grace period. He got laid out. His I-94 is still valid, but he got laid off. So if he moves into B2, which change of status he files from H1B to B2, how does it work out if he later gets a job and wants to move back to H1B? Does he have to do the consular processing? No. The USCIS has tweeted that they would like you guys to move into B2, and from B2 they are going to approve the H1B status with the I-94. And we are seeing that USCIS is following what they are telling it. We have no problem in people applying from H1B who are on 60-day grace period applying for B2. And then later on, when they get a job moving to H1B, we have not seen any problem, none whatsoever at all. We strongly encourage people to move on to B2 and then come back to H1B at a later date. And you don't have to go outside the country at all in the entire process. T Banerjee from YouTube has this question. Do we need to get the court records from every place we stayed in India? How does this process work? First of all, why do you need court records? So the most that they will be asking is the most they will be asking will be the police report, though. Police report should be from the passport office, though. It's not, so police report is from the passport office. Now, court records are only required when there is a case, whether it's a criminal case or whether it's a civil case, that may require some of the civil cases. For example, divorce case is a civil case. You may require to provide your divorce decree to file the 485 application. You have to go to that particular court to get the record. But let's say, for example, if you have stayed in Hyderabad, Bangalore, Delhi, do you need to get the court records from everywhere? No, absolutely not. You just need to get the police report from the passport office. That's all you need. I don't know why you need to get any court records. It's only if ever the USCIS requires, they only require from one particular, let's say it's a divorce decree. They want the divorce decree from where you got a divorce. Or if there is any criminal record, they want the record from that criminal court itself, but not everywhere and anywhere that you have ever lived.
Parole says the I-140 is approved in EB3 with current employer, priority dates 2021, and he's planning to switch jobs to the end client. He needs to know if the end client has to start the perm process all over again. So it depends on when your priority date might become current. So if we're talking country of birth India with a 2021 priority date based on where we're seeing the visa bulletin right now, it doesn't appear that that's going to be current anytime in the near future. So it's possible for you to join this company and work for them for a while. You may then move on to the next company and the next company and the next company. And then by the time your priority date becomes current, that last company does need to file a new perm and new I-140 process again. So yes, at some point, whatever company you're working for you to actually receive the green card, they need to do that process again. But do you have to do it on every single job going forward? Maybe not with a 2021 priority date. But you also have to think about, is there any legislation in the works that might change the visa bulletin to where if you don't file the perm and I-140 with your current employer, are you going to miss out on that? Or what if the EAD-AP for people with an approved I-140 for 5 years comes through and you haven't filed a perm and I-140 with your current employer and don't qualify? So you kind of have to weigh those pros and cons.
The 5-year EAD is only for those people who have adjustment of status pending. It is not for those people who have this is not for the H4 EAD. H4 EAD will be only issued based on your spouse H1B approval, which cannot be more than 3 years. This question is for Nature Lover from YouTube. Second. Can we file H1B, H4 extension together? My H1B expires next year, October, though. Extension can be only filed within 180 days. So since it's expiring in October, which is almost like 11 months, you cannot file the extension. However, if you choose to so, you can file an amendment plus extension. Let's say, for example, your salary is $100,000. And let's say your salary is now $100,050. Can you file an amendment? Absolutely. You can file an amendment and an extension. Now, is it required to file an amendment when the salary is increased by $50? It's not, but you can choose to file if you want to. Sometimes we do that only to get the H4 plus H4 EAD approval fast, because we could do the amendments in premium processing. H4 and H4 EAD, we can't do it. But sometimes we do that just for the sake of getting the H4 EAD approved faster.
Gayatri says, my husband's on L1, and in case of being promoted, do we need to file an amendment with the details of the new role? I think this depends. Number one, is the promotion a material change to the job duties, or is it just normal career progression? And what if this is, he's currently on L1B, specialized knowledge, and now he's been promoted to a manager to where he might be eligible for L1A? Then it might be beneficial to file that amendment and make that conversion. But if it's just normal career progression, you know, even if it's L1B and you get a promotion, if you're still working in that same specialized knowledge capacity, I don't generally think an amendment is required unless it's a major promotion where your job duties are drastically different.
Rohit Mehta is asking, what are the chances for the approval of the I-140 EAD for the people who have 5 years of I-140? It depends on how much noise you make, Rohit. It's like this. What we do is that, you know, you have to do your effort, though. If you're going to chant mantras, will the fruits from the tree fall down? They don't. You have to go and pluck it. The mantras won't do it. So what I tell you is that there is a provision there where we are requesting people whose I-140 is approved. We want you to write letters to the congressman, write letters to the administration to get this thing done. But if you are going to just voice it out, it's more like chanting mantras to get the fruits in your hand. No, you need to climb up the tree or have some stick get out to pluck the tree. Otherwise, you're not going to get the fruit. Now, you need to do the same thing by writing the letters to the congressman, but not just asking the question. You won't do it.
Where did that go? Blessing says, can you talk about the Healthcare Workers Resilience Act? I'm an RN and wondering if this will take effect soon. So this was also introduced last week, I believe, in the Senate, and it does basically carve out an additional 40,000 green cards that would be set aside, part for nurses and part for doctors. And they would become available, but the bill has to go through the Senate Judiciary Committee, markup, hearing, all of that, actually move forward out of the committee, and then it needs to actually be taken up on the floor by a senator who wants to move the bill forward. Then they're going to have debate for the whole Senate to decide whether they're going to make amendments there and pass it. Assuming it passes there, now the House has to do the same thing on their side. They have to introduce the bill, put it through a committee, take it to the floor, get all the amendments, and then finally vote to pass it. And if those two bills differ in any way, the House version and the Senate version, then they've got to come together to reconcile, to come up with a final bill that both the House and the Senate pass that, and then it goes to the president to sign. So to say, will this take effect soon? With all of that to do between now and December 2024, I don't expect it to take effect soon, but it definitely needs people to write letters to show their support for it, to ask their senators to vote for it, to ask their congressmen to vote for it when it comes into the House, so that it can be moved forward and actually take effect.
PV has this question. He just realized that his original birth certificate has been lost. But I do have a copy. He tried to get the duplicate birth certificate. Municipality doesn't have a record. I'm very surprised why the municipality doesn't have a record. If you got it from the municipality, that's number one. Number two is that a lot of the states, particularly Kerala, Tamil Nadu, Andhra Pradesh, and Telangana, most of all the southern states have digitalized these birth certificates. I think so in Andhra Pradesh, they call it as e-seva, and in Telangana, they call it as me-seva, whatever they call it as. You just have to pay 100 to 125 rupees to get the copy of the birth certificate now, which is very easy for you to obtain, though. Having said that, though, if you have a copy of that, most often, though, you won't be asked any question about it to provide the original. But I will make every effort, if I were you, to try to get the original, get it, though. But most of the time, they don't ask original birth certificates for getting the green card. So you may live with it at this point of time. At the same time, try to make an effort to get the original copy from the municipality or e-seva, me-seva, or something like that.
Executable says, what are the repercussions of working outside the MSA on an H-1B long term? Can one apply for amendment at a later date? They're pretty major repercussions. It's very clear under the SIMEO guidance that before work can start in a new location that's not covered by the current LCA, an amendment has to be filed. And if an amendment is not filed and you're working in a location that's not covered by your LCA, you are violating your status. That puts you out of status. Filing an amendment later doesn't put you back into status. It likely will bring out the fact that you have been violating your status and result in a denial. Then you've got to exit the country, have your company file another H-1B requesting consular processing, get the visa stamp, say that you violated your status during your visa application, get the stamp, come back in, and then you're back to work. But it can also cause the 485 to be denied in the future. We actually have that going on right now with one of our cases. So we think we'll ultimately be successful based on some intricacies of the law, but it's a big deal. So we highly recommend that you make sure you're following the SIMEO guidance, make sure your employer's following the SIMEO guidance, file the amendment before you start work in the new location.
Question. When is the right time to request for the EAD for those people whose I-140 is approved? Now, with regards to the elimination of the per country limit, we're telling you guys to wait until next week. The reason is that we don't have a text of the bill at this point of time to draft it. But when it comes to the I-140 EAD, this can be done by the executive order. We don't have to go to the Congress, though. The draft is already there at the links provided in there. You can use those things to write a letter to the congressman or to a letter to the administration to have the EAD. Now, if it's an executive order, can you write a letter to the congressman? Because congressman is not an executive. No, you can write a letter to the congressman to request the administration to do some activity. So the congressman can request the administration to do the I-140 EAD. They can.
Jean says, can I apply for a pre-completion EAD when I have an approved I-140? So I'm assuming you're maybe on F1 and still in your program and wanting to get an EAD or OPT pre-completion before you've actually graduated and happen to have an approved I-140. So the issue with F1 is it's not a dual intent visa category. So while you're on F1, when you apply for the F1 visa stamp at the consulate, when you apply for admission into F1 at the port of entry, when you apply for a change of status to F1, you always have to be able to demonstrate that you have a residence abroad that you don't intend to abandon. So that's showing your non-immigrant intent. I've not seen the filing of an OPT bring up those same issues, because an OPT on that I-765 application, there's no question that asks, have you filed an immigrant petition before? That question is on the I-539. It is on the DS-160, but it's not on the I-765. So I've not seen a problem with doing that, but it is something to keep in mind, keep in the back of your mind, that there is a non-immigrant intent component to continuing your F1 stay.
I see a lot of statements from people that have been in the country for 15 years, have a 17-year-old kid. The prior date is 2012. It's going to take 30 to 50 years to get the prior date to be current, unless there is a change in the law. I see that. I sympathize with you guys. It's very hard. I understand. I went through the process. Unfortunately, I didn't have to wait that long, though. At that point of time, the date was current. When I got the green card, the date was current. Believe me, the next month after I got it, the date was not current. It went back. And I know the pain of it. Those people who were just 1 month behind, they had to wait for 3-4 years to get the green card. Now, that's a story for those people who got the green card along with us at that point of time. But now it's very sad story. I sympathize with you, but you have to understand that it's not in the hands of me or Emily Neumann to pass the bill. It is not in our hands. It is in the Congress hand, and we are not the congressmen. We request you to contact the congressman to do the work. Emily can't just pass the bill. I can't just pass the bill. And if we were to, believe me, it'll be passed by the time this video ends, which is going to end in the next 10 minutes. We're going to pass the bill in the next 10 minutes, but it's not in our hands. Congress has to pass it. You have to strive. I know that you have done so many struggle. I know that you have done so many times you have write the letters. You're in a sad situation, but still, it's not an excuse for you to not write a letter to the congressman, not contact the congressman. Please keep the persistency and have every your friend also involved in it. Friends, family members, colleagues to write it. Now, we are not asking anybody to give any special preference to Indians. All we want is everybody should be treated equally. We should not be looked into the color of us. They should not look into our country origin when they are giving the green card. That's all we are requesting.
Idris says, how safe is it to travel to Canada for 2 to 3 weeks without the H-1B visa stamp using automatic visa revalidation, or AVR? Are there any potential issues with re-entry? I originally entered the U.S. with an F1 stamp. So automatic visa revalidation allows you to use either an expired visa or a visa that's in another category. Travel to Canada or Mexico for less than 30 days, not apply for a new visa stamp, and return to the U.S. as long as you have a valid I-94 for your current status that has not expired. So in this case, you originally came on an F1, so you have an F1 stamp in your passport. I'm assuming you got a change of status to H-1B approved that came with the I-94, and that I-94 has not expired. So that means, yes, if you're traveling for less than 30 days, you can go to Canada or Mexico without getting the H-1B stamp in order to return to the U.S. This is assuming you don't have any immigration violations in your history, any overstays, any criminal issues. Those are the types of issues that can come up with reentry. But if you've maintained your status, not run into any trouble with criminal issues or anything like that, it is relatively safe.
Birth certificate is from the Consulate General of India in USA. Will it be acceptable for 485? No, it has to come from the municipality or the government, state government. It cannot come from the consulate, because all the consulate does is that take the passport and then say, hey, this guy is born on this one based on the passport. They do not accept the birth certificates from the consulates.
Vipin says, my perm is pending for more than 1 year and I'm on H4. Can I get the 7th year H-1B extension now?
Good question.
So I'm assuming that you were on H-1B and you hit your 6-year limit, or were about to, and your perm wasn't filed early enough, so you changed status to H4, and now your perm has been pending for 365 days. yes, you absolutely can now change status back to H-1B and get a 1-year H-1B based on the fact that your perm has been pending for 365 days. By the end of that 1 year, you need to have either your perm still pending or your I-140 approved to be able to get the 3-year extension after that.
I received an EAD associated with the 485 application. It's less than 180 days. Can I switch to H-1B? Will it affect the ongoing AOS or AP? What do you mean by switch to H-1B? I'm assuming switch to EAD. I'm assuming that you're also wanting to change the company from company A to company B. It doesn't have to be 180 days from the time you got the EAD to switch the company. What is required is that if you want to switch the company, it has to be 180 days from the time you file the 485 application. Once you hit the 180 days after you file the 485 application, you can switch the company. Absolutely not a problem.
Sundeep says, another automatic revalidation question. My wife has a valid I-94 expired H-4 stamp and no I-797 since she entered on H-4 using my H-1B approval notice, the new one. Can she travel to Mexico or Canada for a vacation? Yes, so that valid I-94 doesn't have to solely be attached to an I-797. If it's an I-94 issued by CBP previously, and that's the current I-94 and it's unexpired, that works too.
Kiran has this question. He filed the 485 application. He filed the prevailing wage in July 2023. His max out is February of 2025. But he spent 1 year and 4 months outside the country. His employer doesn't know. What's your suggestion? First of all, if you filed in July of 2023 prevailing wage, then most probably it's going to be almost February or March or April 2024 by the time you get the prevailing wage plus. So that's you may not be getting the labor and I-140 approval by 2025 February. You may have to disclose the information that you're outside the country and claim that 1 year and 4 months, in which case I'm assuming that the 6th year is actually not maxing out in February of 2025. It's actually is going to max out 2025 February plus 1 year and 4 months. That's what I'm assuming. But if it's only February of 2025, you're maxing out, you may want to consult an immigration lawyer immediately because you need to have plan B in action. What is the plan B? Sometimes you may have to spend extra time outside the country. Sometimes you may consider H4 EAD options. And you also need to H4 options or H4 EAD options if you have those options. You may want to also consider the fact that will your company be cooperating with you? If you stay in this country and B2, that's something that you can consider. The other option is that if you go outside the country, will the company cooperate with you in getting the labor and I-140 approval when you're not working for that company? So all those things need to be analyzed, and you should make a decision right now, not go all the way to February of 2025 and then try to scrabble at that point of time.
RK wants to know, after filing a standalone I-539 and I-765 extension, can the H-4 applicant do the margarita switch to get the extended I-94 based on the primary's H-1 validity? And what happens to the pending I-539 and 765? And can the H-4 continue to work? Yeah, so assuming the current H-4 has not yet expired, yeah, we had a lot of people, especially during the last few years when they were unbundling the H-4 EADs from the H-1B, travel using automatic revalidation, coming back, showing the spouse's H-1B approval to get the extended I-94. And then because you have the extended I-94 and an already pending 765 renewal, you can work based on the pending extension for up to 180 days. And based on our experience, sometimes the pending I-539 will be administratively closed because you already got the extension you were asking for. Sometimes they'll just deny it because you already got the extension, or sometimes they'll just approve it for the extension that you already got, but it should not negatively impact the pending EAD.
NMP has this question. His wife got EAD but not AP. It's been 6 months that she got the EAD but not AP. Does she need to refile the advance parole? No, she doesn't need to refile the advance parole. It happens very frequently that the EAD is approved and advance parole is not approved. You just have to wait for the advance parole approval. Anything else, Emily?
All right, I think we are out of time for today. Thanks everyone for joining us. Remember to hit that subscribe button so that you can get the latest updates on when we go live and all of our videos. And make sure you can contact us through our consultations as well. If you need to have more detailed information about your situation, you can go to rnlawgroup.com and click on consultation and book with us or any of our attorneys at Reddy Neumann PC.
Thank you very much for tuning in.